Good afternoon, everyone. The time is now 3 p.m. I will go ahead and call to order the April regular meeting, that is, of the Board of Elections and Registration. I'm calling that meeting to order at 3 p.m. The first item on the agenda, or that we will undertake, is I welcome all of those that are willing and able to rise with me for the recitation of the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first item on the agenda is the approval of the agenda. Has everyone had an opportunity to review the agenda?
Yes.
Yep. Are there any proposed revisions or amendments to the agenda? Hearing none, I will entertain a motion for the approval of the agenda.
So moved.
Thank you, Mr. Bruning. Is there a second?
Second.
Thank you, Ms. Fisher. It's been moved and properly seconded to approve the agenda. All those in favor? The motion passes unanimously. Next up. Thank you very much. Next up is public comment. My understanding is that no one signed up for public comment to participate virtually. Okay. We have 6 individuals with us that will participate in public comment, and first up is Ms. Christine Rosman. Yes.
Thank you, Chair. Hello, Board. Christine Rosman, Cobb County, obviously. I just have a couple of questions on the bylaws that you're going to approve today, because I just had some questions on it, which is it says that the public meetings shall be open to the public and conducted, whatever, and I'm sorry, I want to do one more before that.
Mm-hmm.
The Article 4 about the officers, and it says about the vice chair and the chair being selected, but then it doesn't really say that the secretary is selected, or I guess elected among the 5 of you or whatever. And I was just curious, because then that has an effect on if the chair and the vice chair are not available, then you have your secretary that takes over that role. And so it just seems that that would be somebody that the rest of the board would select. So if you want to address it when you address that, that would be nice. Okay. And then the other question I had was about having the special meetings. And you've had special meetings in the past, but I've noticed that there was no public comment in the past if you had a special meeting. And I just wanted to see if that is in alignment with the way that it's according to the Open Records Meeting Act. Because I did notice that there were several times you had special meetings and nobody could speak. The other thing I'd like to address is the Secretary of State has like 400,000 people that are going to be taken off the voter rolls. And I was just curious what Cobb County is doing to prepare for that. I don't know if Brad Raffensperger is going to be working in conjunction with the counties, how that's going to work, but I do know that I witnessed several citizens come forth with a lot of people that were not eligible to be on the voter rolls, and I just wanted to know what you all are doing to be proactive about it. I found it very disconcerting when he was talking about how many people, and the more talk you hear about how many people are like 100 years old and voting, or 150 years old and voting, people that haven't lived here for 5 years, 10 years, but I don't understand why they weren't automatically taken off. if you could maybe address that. And because it's kind of like, if I have a pantry and a refrigerator full of food, but it's all expired, or not all of it, but you have cans of goods that, canned goods that are 10 years old, that's not really in your inventory, nor is rotten food in the refrigerator. And that's the equivalent when you have people that have no reason to be on our voter rolls, that their names are still on there. Thank you.
Thank you, Ms. Rossman. Next up is Leroy Emkin.
Leroy Emkin, live in Cobb County, 25 years. I'd like to read something from the United States Supreme Court, New York Times versus Sullivan. The subject was the First Amendment principles during periods of public comment. Perhaps the most fundamental of all First Amendment free speech principles is that individuals have a free speech right to criticize the government. In the New York Times versus Sullivan case, U.S. Supreme Court Justice William Brennan famously wrote of a, quote, profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials, unquote. I assume the word attacks means verbal attack. When we all stood to cite the Pledge of Allegiance, 4 members of the Board of Elections turned around, faced the flag, and cited the Pledge of Allegiance. In honor of our country, those who served and gave their lives to protect our freedoms and our Constitution, one member of the Board of Elections, Ms. Jennifer Mosbacher, sat with her back to the flag, with her eyes facing down, and she apparently refused to cite the Pledge of Allegiance. This demonstrated incredible disrespect for our country, our Constitution, our way of life, our freedoms. Disrespect for those who served in the military, those who, our police, fire, medical, and other first responders. Incredible disrespect for all of them. I wanted to say this so that the record showed, consistent with my First Amendment rights and the Supreme Court case, I would like the record to show that Ms. Jennifer Mosbacher continues not to say the Pledge of Allegiance in her official position as a member of the Board of Elections. Very, very disappointing, and I would hope that the other members of the Board of Elections would provide her with appropriate advice as to what the respectful behavior should be when we say the Pledge of Allegiance. With respect to the voter rolls, I heard what Ms. Rossman said. I think it would be useful for the Board of Elections to help the citizens in this county to know how we in Cobb County are assisting the Secretary of State to remove people from the voter rolls who do not belong on it. How are we in Cobb County going to help the Secretary of State with respect to those citizens in this county who should not be on the voter rolls? It would be of great value to us to be aware of that, because most of us, the few that are here today and many, many others in the county, are very, very concerned about those who are not legally qualified to vote are in fact voting. So we hope that you continue to do what we believe you will do, and that is to assist the Secretary of State. Help us understand to what extent you will do that. Thank you.
Thank you, Mr. Emken. Next up is Mr. Hugh Norris.
Good afternoon, Board. Hugh Norris, resident of Cobb County since 1997. Or you can refer to me as Johnny One Note, because I'm going to bring up a subject I've brought up many, many times before. We witnessed Ms. Mossberger, who I believe is the Mossbacher, is vice chair of the board. She's part of the leadership. And I just get more concerned all the time. And the reason why I do, a little history of my past. I've had family that served in World War I, World War II, the Korean War. I myself am a Vietnam-era veteran. Era means I did not serve in the Vietnam theater. I served in Africa in an intelligence unit. I also have family that graduated from West Point and Annapolis. So I understand what it means to serve. I take the loyalty to our nation very, very seriously. So surely you all would understand that I have no respect for the leadership or the majority of this board that I'm addressing at this point. No respect. It's surprising to me that none of you have family or friends who have served or are serving in our military. If you had such connections, maybe you would understand and act appropriately and require that Ms. Mossbacher explain herself, and perhaps she doesn't belong on the board. Thank you.
Thank you, Mr. Norris. Next up is Mike Benz.
Thank you, members of the board, for the opportunity to speak. Mike Benz, Cobb County resident for 20-plus years. I wanted to address, again, this recurring theme of ineligible voters on voting rolls, which has been shown not to be correct. That is just not true, but the reason it's not true is because you're doing your job and you are cooperating with the state for voter roll maintenance and doing everything. And when there are challenges that occur, you address them promptly and according to the rule of law, not according to someone's feelings about things not being the way they want them to be. So there were a couple of mentions about the Pledge of Allegiance and a lot of comment about how someone's First Amendment right extends to being able to criticize and use sharp language. And, you know, becoming a elected official or an appointed official does not mean that you lose your First Amendment right to express yourself. And one of those expressions, as in a 1943 Supreme Court case, determined that there was absolutely no way to compel someone to stand or to repeat the Pledge of Allegiance. I have a lot of connections with family in the armed forces, and they pledge to defend the Constitution, not the piece of cloth that they're carrying into battle over their heads. So to go making and equating a flag, a piece of cloth, with what actually is being defended and what they stand for is a gross misrepresentation, just like you as public servants take an oath, not a pledge, but an oath to uphold the law, not according to a few people who have their feelings that are so bruised, they have to come and attack someone who's obviously not complying what they think should be done. The law does not allow you to compel anyone to stand with the pledge. It's not up to you to dismiss someone on the board who makes a citizen upset. And so, again, yes, First Amendment, thank you very much. And I will be in solidarity with others because I personally am starting to wonder what the pledge is actually to. Is a loyalty pledge, is it to whatever is going on right now with the destruction of the economy, with the destruction of civil rights across the country and dismantling the Constitution? Is that what that pledge stands for? No, I cannot support that.
Thank you, Mr. Benz. Next up is Pam Reardon.
My name is Pamela Reardon. Good morning, board, or good afternoon. I like your glasses, Tori. So, which one do I do first? Okay, the flag. The flag is a piece of cloth, but if you think that it's only a piece of cloth, you're sorely mistaken. It means everything to the country, to the people who serve, and I mean, I really don't care if there's a member, personally, that doesn't want to stand. It doesn't bother me. But it shows me that she doesn't respect the Constitution, and it makes me wonder whether she is really there to do her job to protect our elections and make them fair. So the other thing is on the voter rolls. You know, by now you've heard that they have found millions of illegals that came in through Biden illegally and maybe under the auspice of a parole, but it was still illegal, that were given access to Medicaid, Social Security, therefore have Social Security numbers, therefore have voted. And I just want to ask this board, are you checking on those? Are you doing anything about that? Is there any way to find that out? Because I assure you, we have lots of people on there who have voted illegally. I can name one, but I'm not going to bring it up right now. So, that I personally know. So there are, that is out there. And I know that it's time that the SOS deletes, you know, the bottom 8 or the bottom 4 years off the voter rolls that have been on there as status, you know, inactive. But it's not really inactive because they can activate themselves at any time if they happen to come to vote. So anyone can register to vote in less than 5 minutes. So I really don't know what the push is against removing people from the rolls, only that it will save money because you don't have to keep on sending out notices to people who are really not here and not voting. Thank you very much for listening.
Thank you, Ms. Reardon. Next up, and our final person participating in public comment is Mitchell Redd.
Good afternoon. I'm Mitchell Redd, and I live in the Cumberland area, and I would like to highlight a couple of ongoing voter suppression attempts that are occurring in our state, especially given that we've wrapped up the legislative session here in Georgia.
I apologize for interrupting you, Mr. Redd.
Oh,
And folks, yeah, just come a bit closer.
Okay, I'm sorry.
Individuals in the area said they could not hear you.
I'm sorry.
No worries.
Well, again, I'm Mitchell. I live in the Cumberland area, and I'd like to highlight some current and ongoing voter suppression attempts that are occurring in the state of Georgia, especially in light that the legislative session is wrapped up. The changes get worse year by year. Senate Bill 202 in 2001, it tightened up the absentee timeline, made provisionals a lot harder to process through, a lot of other things. Senate Bill 189 in 2024, unlimited challenges to registered voters, unlimited challenges to registered voters, no consequences if it's a failed challenge. There was an amendment, if I remember, to that piece of legislation that would have, made a person, a challenger, susceptible to a civil penalty if their challenge failed. And given the fail rate is so abysmal with the challenges, I think that many of our people here, they would have been in bad luck if they would have had to have faced a civil penalty for a failed challenge. Then, our most recent attempt this past 2025 legislative session was House Bill 397, which it did not pass both chambers, but it's still going to be alive and kicking when they gavel back in for 2026. It's worse and worse. It would remove Georgia from the Election Registration Information Center. It's an organization that many states opt into that can detect when people have moved states. It's a great asset for states to clean their voter registration rolls and keep them up to date. It uses legitimate death data from the Social Security Administration. But the silver lining of that bill is that this political party, they want to push the state toward Eagle AI, which is a software tool that was developed by a doctor. And to me, it's just homebrew software that instead of using official death data from the Social Security Administration, it uses online obituary data. That's really reliable, and it runs afoul of the National Voter Registration Act in every single way. And it's another item in a long list of voter suppression attempts by one party to cause chaos, confuse people, hurt people, and at the end of the day, shut people up. And I'm here to highlight those things and to say that voter suppression is alive and well. Thank you.
Thank you, Mr. Mitchell. That concludes public comment. Next up on our agenda is the approval of our meeting minutes, and for the meetings that were held during the month of March, we held 3 meetings, that being our election night meeting on March the 11th, our pre-certification meeting on March the 14th, and our regular certification meeting on March the 17th. Has everyone had an opportunity to review the meeting minutes for each of these each of these meetings? Okay. Does anyone have any proposed revisions or comments to the meeting minutes? Hearing none, we'll entertain a motion to approve the meeting minutes for each of the meetings having been held on March 11th, 14th, and 17th.
So moved.
Thank you, Mr. Bruning. Is there a second? Second. Thank you, Ms. Fisher. It has been moved and properly seconded to approve the meeting minutes for meetings held on March 11th, 14th, and 17th. All of those in favor? The motion passes unanimously. Thank you. Next up on the agenda is old business. Those of you that may have tuned in or been in attendance, I believe it took place in February, the board undertook a revision, or is proposing to undertake a revision of its bylaws and amendments. Pardon me, bylaws. Yeah, it's amended and restated bylaws. Those proposed bylaws have been circulated to the board following the robust discussion that we had at our February election night meeting. And I know that our counsel, Daniel White, maintained a listing of the revisions that we discussed, and I know myself and board member Stacy Affret provided some additional proposed revisions following Mr. White providing a proposed updated version. I don't recall receiving anything further. And then obviously the bylaws have been posted for the public to view as well. So at this point, I want to raise the question, does anyone have any comments or concerns, noting that there were a few that were raised during the course of public comment? I do believe it would be appropriate to address them. I know we don't generally engage in conversation going back and forth with respect to items that were raised during public comment, but I do believe it would be appropriate for our council in one respect. And I think it might have also been one of the comments, I think we've already addressed it, or at least I addressed it in my revisions. So, but does anyone have any comments or suggestions or proposed revisions?
I do.
Okay.
And I believe someone mentioned it in the public comment, and that is Article 4, I think it's C. No. Article 4, Section 1. The chair and vice chair shall be selected in the manner prescribed by law and shall serve for a term of 2 years or until successor is duly appointed and qualified. Why is the secretary not also selected by the board?
I believe Mr. White will address that.
Sure, I can address, I was gonna, if nobody else had brought it up, I was gonna give Ms. Rossman a shout out and say thank you, that's a good catch. But if you remember when we were going through this, originally the board had discussed having sort of a staff member serve as secretary/clerk and making
Right.
that one role. And so we had, the original draft had that language in there, and then when we were going back through and doing revisions, I think maybe on the second round of revisions, and we put the secretary back in there, and that's just because we needed if 2 people are missing, we need a third person, to step in and serve as, to run the meeting. So for some reason, the chair and the vice chair, and there's other roles the secretary could possibly fill. So that was inserted back in, but it was not, Article 4B1, that we want to add the secretary back in up there, and that's just one that, when you're drafting and you're making multiple rounds of revisions, sometimes you don't, you don't catch all the places it ties back in. So that's a good catch, and I'm glad this is why we need members of the public paying attention and giving feedback. So yeah, I would recommend we add that
I
back in
didn't
there.
catch it on
I know,
your last round, but I
We've all
did
read it so many times.
I did catch it when I was reviewing it one last time yesterday evening. And the secretary being another bone of contention I have, is I'm okay with the director appointing a clerk, but listing it under the officer duties,
Yeah.
I'm not sure that's an appropriate place. They are not an officer. And secondly, can you please clarify, is that clerk going to be allowed in executive session? Because I believe we are required to have a minimal set of minutes in executive. And I don't think it would be appropriate to have a staff member in executive.
Yeah, I will say that what was provided to us is the red line version with the proposed revisions accepted. What was, just so you know, for example, you made certain revisions, pardon me, Stacy, you made certain revisions to the one section that we were talking about, and I believe that that was what was provided to the staff. But what we have here in front of us has those revisions accepted, because I know what I provided, same thing, this role is not an officer and should be placed under a different heading with respect to the clerk. And then, Stacy, your notes show that we're removing the secretary. So hopefully this is making sense.
Yeah.
You're
And
looking at me
just
like
to-
it doesn't.
Just to comment, we don't publish any notes, we don't
We
require
don't
any-
publish, but we are to take them by law. Yes, we are. We are
Well, you
to
take
have a
minutes.
set of minutes for executive with the chair's signature, I believe. If we're not doing that.
Yeah, well,
Then-
that's, you do need to take minutes in executive session, and I was under the impression that, that someone was.
My understanding is that we were taking minutes in executive session.
Well, apparently not. The
I
secretary has
take my own
spoken.
notes. I take minutes of executive session. I don't publish them with the minutes.
No, we don't
because-
publish.
I
They're
di-
not for
I didn't say
publication.
anything about publish,
Right.
but I have a real issue with a staff member being in executive. And thus, the secretary is not granted the duty of doing minutes. I think that is a short-sighted miss.
Well, in general, there's nothing wrong with having staff in executive session. I mean, that's, you can invite in whoever you want to executive session, and I'm not sure what the general principle is behind not wanting a staff member. I mean, just, maybe you just want to keep it only among board and council, but, director falls in there usually, if it's a litigation issue. So
Do they
there-
take an oath?
What's that?
Do they
It
take
doesn't have
an
any,
oath?
that doesn't, what does that mean?
I don't know that
That
Director
doesn't,
Falls
you don't have to
takes
take an oath to go into executive session, Debbie.
No, you don't. No, you don't.
You just have to be, you're just bound by attorney-client privilege, so you gotta be, to the extent they're part of the organization. There are different purposes for executive session, and,
There are.
there's 3 limited ones that this board can use, and none of them, they're just,
Or we could just have the secretary take executive session minutes and
That's
then
fine.
everybody's happy.
And I don't have a problem however you want to skin it. I just want to point out there's no prohibition against,
Right, well, it sounds like it is going to be resolved by default to the extent that a secretary role will remain on the board, notwithstanding the conversation we previously had, correct?
Right, yeah, that's
Okay,
correct.
Well,
so,
then wouldn't you need to resolve it under the secretary's duties as well?
I believe so, but I think we're just getting to that point, because again, coming out of the meeting, we were considering having no secretary, role on the board. But
Yeah,
now
yes.
that we know that we will have a secretary role on the board, unless there is an objection among board members, so can we take that piece up first? Is there an
You're the chair.
objection among board members to have the secretary role? It kind of goes back to Article 4, Section 1, subsection B, Romanet 1, where it is suggested that the chair, vice chair, and secretary be selected by vote.
I had that stricken. I've actually, my notes about it are from reviewing it were that we did not have a secretary role. So I didn't know when it came back in. I did not go back and listen to that whole meeting again, but I did not
I don't
recall
know
we
that
put
it came,
back in.
I don't know that it came back in the meeting. I believe it was this desire, and jump in here, Mr. White, if I'm putting words into your mouth, around this chair pro temp in the absence of the chair and the vice chair. Was that the thought process behind adding secretary back in?
The thought process behind adding the secretary back in is that you've got, in this case, you've got 3 people that could run the meeting, and if you're
Right.
missing those 3 people, you don't have a quorum, so you wouldn't have a meeting. So if, let's see, 2 of the 3 had to be missing, you're always gonna have somebody there who says, this is the person who starts the meeting and runs it. So the idea was just to put the secretary back in, and I had done that in between rounds. Like, we had stricken the secretary, and we're gonna make it the staff duty. And then, but in the meantime, when we were cleaning up the officers section, I was thinking through the quorum and who's gonna run the meeting if somebody's not there, then I said, well, we probably wanna keep the secretary, but just really as a backup to the backup, but that's fine, it's
So
fine.
it wouldn't have been if you had gone back and reviewed, it wouldn't have been there, because following
Okay.
the February election night meeting, obviously Mr. White took it upon himself, as we asked him to ensure that the draft that was circulated to the board was reflective of the conversation that we had. And it was during, as he shared, during the course of making those updates, that he then realized what he realized. So you didn't miss it and your notes are correct, but I didn't object to it in my proposed revisions to what he provided to us, I guess about, 4 or 5 weeks ago, because it's rational to me. But I guess that's why I go back to, before we get to who's taking minutes and who can be in executive session, are we in agreement that a secretary, to Mr. White's point, are we in agreement that a secretary role should remain on, as it currently does, on this board for the purposes that he suggested?
Yes.
Yes.
Okay. That's just the general, if somebody,
I don't see a reason to remove the secretary as an officer. That didn't make sense to me from the get-go.
Well, what it was is, and you see this with other bodies, is where you'll have, instead of having a secretary, you have a staff member that serves as the function of a secretary/clerk. And so here, we had substituted that in and made a staff member sort of the secretary.
Which I'm okay with, but I still think I don't see why we would object to the secretary being an officer under the manner in which you wrote.
Yeah.
I do think it needs to be addressed that someone is in exec to take minutes, and it makes no sense to have an objection to not electing a secretary.
I don't know that there is an objection to the election of a secretary. I think we need to get to the point of whether this body believes that a secretary should exist. And then to the
Two
extent,
board members didn't answer your question, so maybe we should do that straw poll.
or we can simply have a motion. And then get into the discussion then.
So,
Why don't, why don't I propose this? It sounds to me like everybody's okay to leave the secretary in.
I don't know, it didn't sound like that initially, so.
Is any, well, and that's what I'm gonna say, we could just, I was just gonna say, I've added it back into the draft, and you can, I could go back through when it's time for a motion and state the amendments, and then you can, I mean, unless you think you need to vote on them all, separately, but.
Okay. I don't know how many there will be, so
Yep.
I guess to the point with respect to a straw poll, is there any opposition to the secretary role remaining on the board? I guess that's the question.
So, I'm not opposed to the idea of having a third in line documented, I don't, whether they're called secretary or whatever, that is not my point of contention. I think we were trying to take the note-taking away from a board member and give it to a staff member. So,
And I think you can still do that.
yeah, so I guess that's where I'm coming from is, I don't dispute the need to have a third person in line to run a meeting if the other two can't go. And that's a separate job than having a designated board member taking the notes.
Right, and I understand I've not held that position, but I also recognize that if any board member is taking notes and doing so in the manner in which I know that the two of you all are, it may reduce your ability to engage in the conversation. That makes logical sense. So perhaps it's a matter of having a secretary that can serve as the third person in line, if you will, to run the meeting. Also include the clerk. Well, there will be two kind of functions, if you will, for the secretary. Potentially to run the meeting in the absence of the chair or the vice chair, and to take meeting minutes, which we all know are not published, during executive session. We could also keep the clerk in here, move the placement, because obviously, as was noted, they are not an officer, and place the obligation for taking meeting minutes in the meeting section.
I personally don't have a problem with a clerk being in an executive session. Like, if Daniel thinks it's fine, then I don't have a problem with it.
Except for the board can decide who they.
Right, and there are times where and nothing pejorative, there will be
Right.
times where we ask Ms. Fall to leave out of executive session.
Right.
So if it's a matter of there being a sensitive conversation that we don't believe, as a board, do not believe that the clerk, i.e. the office staff member, should participate in, we simply ask them to leave.
I agree.
Okay.
How about, let me make this suggestion that could probably deal with both. What if we just leave clerk where it is, but, well, I was gonna say, or add it to the secretary, and just say basically, I mean, the secretary typically has the note-taking and the record-keeping role, and we could just say that the elections director shall designate a member of the elections department staff to assist the secretary and serve as clerk. And that could leave it under we have someone who's assisting, a staff member who's assisting the secretary with those
Understood.
jobs, and then we just leave it in there.
I think that's a good solution.
Okay, so it sounds like secretary remains, clerk remains for the purposes of assisting that secretary, and
And we can add a clause at the end of either one to say that the secretary will take
will be responsible
keep
for
minutes
taking, okay,
in executive session.
okay, got it.
I'm okay, I agree with Stacy, though. I'm definitely okay with the clerk taking notes in executive session, if that's,
You can just make it a case-by-case
okay,
basis.
that's, as long as I feel like it shouldn't be like the mandatory job, if that makes sense.
Yeah, sure.
And then I think under section 1.1, it needs to probably say the chair, vice chair, and secretary
It
shall
does.
be selected in the manner, right? Like that's where we need to add.
Yes.
Right,
We're all in agreement on that.
okay. You have all of that, Daniel,
Yes, and I'll read these out at the time.
when we get to it, okay. All right, Debbie, did you have additional comments or proposed revisions? And if you'll give us a section reference too.
I believe I had added something on my recommended amendments that apparently did not make the final round. But I agree with whoever it was that was speaking publicly about special call meetings and having public speaking. I voiced this every time we've had a special call meeting in which we were taking a vote or deciding on something. I don't believe that it's proper for us to disallow public comment when a vote is being called and it's on something that we are determining, whether it as a resolution or anything else that affects elections without public comment.
Okay, so that's Article 6.
Oh, I'm sorry.
Oh, no,
I'm
you're good.
sorry.
Article 6, Section 2, Section 3, special meetings.
Section 3, yes.
During public comment, Mr. White, there was a reference to the Open Records Act. If you will advise us whether there is an implication to the, the open meetings requirement of the Open Records Act. Is there a,
So there's an Open
Are we
Meetings Act and there's an Open
conflating? Yeah,
Records Act, and I
conflating.
think they were conflated, but
Yes.
neither of them apply. I mean, Open Meetings Act always applies to your meetings.
Mm-hmm.
I mean, you always have to comply with 5014-1 and all of the sections that come after, but there's actually no requirement that you have public comment at all. I mean, it's not in the it's not in the Open Meetings Act. But, there's plenty of boards in this state that don't have public comment. This is something you do, and you do it at your regular meetings. And you'll see this at a lot of, county governments, but city governments too, where you'll have your regular monthly meeting is where you have public comment, and you have people come sign up, and it's predictable, and but if you have a special called meeting that's, usually special called meetings, you say, hey, we need to come in and we need to pass this specific bond measure, or we need to do, so public, a lot of times you're having special called meetings because you have a specific purpose. So it's not necessarily helpful or even sometimes not appropriate to have public comment in a meeting that's called for a special purpose when, it's not your regular meeting, so maybe not everybody plans to be there or know or comment. So it's very common. I mean, it's more uncommon to have public comment at a special called meeting than it is to have it at all meeting. I mean, it's not the exception to not have public comment at a special called meeting. It's actually the exception for boards to have public comment at a special called meeting. I mean, that's the whole reason it's called a special called. It's like you're here for a special purpose, not for the general monthly, we're gonna have public comment. It's the same reason you have this board never, even before we were in this building, even at the old, back before we were in a building with flags and things like that, we would have election night meetings in, there's no public comment then. We had special called meetings in, there's no public comment then. The public comment was at regular meetings. Now, that's a board policy thing, and if the board wants to change the policy, absolutely, but there's certainly there's no Open Records Act at all, because this is an open meetings issue, and there's no open meetings issue because that's not required. Public comment is not required under the Open Meetings Act.
You are correct on the Open Meetings Act that there is no requirement. However, I think there is a responsibility of us for full transparency. I think we should hold our special meetings. A lot of times, yes, they are necessary. Yes, they're last-minute things. But if it's something that is scheduled that kind of keeps the public from being able to comment on something we're going to be required to vote, I just like it on the record that I have a serious problem with that. Otherwise, I wouldn't be consistent with all of my objections prior to today. So I am being very consistent that I agree with solid transparency versus what is in the Open Meetings Act, what is Open Records Act, which isn't affected here. But I am all about transparency and giving we the people the right to speak. So.
Okay. Does anyone have any, thank you, Ms. Fisher. Is there anyone else that wants to be heard on this section, again, Section 3 of Article 6 about special meetings? As it currently reads, special meetings may be called as necessary by the chair or a minimum of 3 members of the board with proper notice, published pursuant to OCGA 50-14-1. Reasonable notice shall
reasonable prior notice shall also be given to each member of the board prior to scheduling.
I would just prefer to keep it as is. I know we hashed it all out in that multi-hour meeting a month or two ago. So I would like it to stay as it is.
As is, in as much that it would not be this board's standard practice to have public comment during special called meetings.
Right, keep public comment at our monthly meetings, as Daniel said. It's predictable. It's our standing public comment opportunity, and then special called meetings are there for special purposes.
Okay. Does anyone have anything further they want to share with respect to this topic?
I would just like to say
Yes,
I
sir.
agree.
You agree with Ms. Catherine?
Yes.
Okay. Anything else? Okay. So, anything further, Ms. Fisher?
Nope.
Nope. Okay. Ms. Afford, looks like you have something as I look at this.
I was just turning off my mic.
Oh, sorry. I wasn't trying to ignore you. I was just scrolling through. I think the rest of the revisions were more nits than substantive. So
I
it
have
sounds.
one question.
Oh,
if that's
I
okay.
apologize.
Nope, totally okay, totally. It's for Daniel, actually. Under Article 7, Section 1A3, I had a note that you were going to put in a citation for that, like a OCGA, but I don't know if that was, there was a lot of things going on then.
Isn't that under local code?
Yeah, that's.
That's local.
I don't know if that's, I went back and listened to it and I didn't hear, but my comment may have been that was taken directly from the,
From the enabling
from the
legislation?
enabling legislation,
Okay.
which in turn is a reference to the election code. So this language about subject to removal, I just pulled that straight out of the enabling legislation because that's the only authority you have is
Right.
whatever you're given in the enabling legislation. And then that in turn, this part about the authority provided for the removal of registrars, that's what the enabling legislation references. So, I mean, if you wanted me to go quickly pull up that OCGA thing about the removal for registrars and put it in there, we can, but that's what that would be.
I guess I just looked at it from like a future board perspective, like it's not something you can take, like we had kind of debated it as, is this something we can take out or how do we look at this? And you were like, no, this is actually how it's written. So I
Right.
didn't know if maybe we wanted to put, I made a note that said OCGA 21270, but I don't know if that was 100%.
Well, 21270 is your duties.
Okay. So that's not where that is.
That's not where that is. I think that you may have been noting that to see like, is that where your powers were, where this was derived from? But no, this was pulled out. And the reason I didn't cite the legislation is because the legislation is not cited in the enabling, like the OCG,
Okay.
the election code is not cited in the enabling legislation. It just says it's by the authority as provided for the removal of registrars. And we can do that, but it's sort of like if they reorganize the election code at some point, then you can kind of
Then
come
you've
back and
got that in there.
change your bylaws, and, I mean, that's fine, but.
Nope, that's totally fine. I just wanted to make sure that my note was, yeah. Okay, so that's fine. We're good. That was my last note.
Does anyone have anything further?
I think there was a note, and actually, was talking with Director Fall about this, on the same section there, it's,
And
Article
appoint subsection 4?
Yes.
I think that was my revision in the last line.
Yeah, the interim acting director, is that,
Whenever there's an absence of a director, either due to FMLA leave or military leave, so they're leaving and coming back, the county uses the term acting director, and they use the term interim director if someone's left and they're not coming back. So just an administrative term the county uses. So section 4 would be acting director, and then section 5 would be interim director.
Okay. So section 4 would then read with that distinction between acting and interim. In the event of a planned or unplanned continuing absence of the elections director that exceeds 30 days, the board in coordination with the elections director, when possible, will select, I had added the language and appoint, and And then as opposed to it reading interim, it should read acting?
Yes, just to be
Okay.
consistent with county language.
Acting elections director is what I believe it should read.
Okay.
You would drop the word interim?
Right, that's the point that's just made. Acting is when you know they're coming back. So
Right.
if there is an unexpected departure of the elections director, we know that we know that they're not coming back, then interim would be the appropriate reference, which would then be in section 5.
Correct.
Okay. Are we all clear on that? Okay. Right.
And I'll, if we're gonna do, acting elections director in sub 4, then we'll make the same change in sub 5 where we do interim elections director.
Yeah, I think that would be appropriate. Because unless we were to change the defined term to director, but it's elections director in every instance in which it's used in here.
Sure.
And then again, in the version that I circulated, there were just some like nits to clean up. Those have been accepted. I presume we're all fine with them. For example, that in that same section, the elections director, it initially said, shall be responsible to administer the fairs. The elections director shall simply administer the fairs. Like, I don't know that we would have to say shall be responsible to. The elections supervisor was referenced in section 3, just above section 4 that we were just speaking of. It's not the supervisor, it's director. So again, I think those were just nits to clean up. Hopefully nobody has any concerns with those. All right, so it sounds like there are 2 substantive revisions that we've discussed. One with respect to the secretary remaining, a member of the board, the clerk being referenced to assist the secretary with respect to minutes, and that assistance is provided both in the public meeting as well as executive session. Everybody aligned on that? Yeah. Okay.
Do you mind if I read, there's a motion,
Okay.
I would like to go through and just read all the changes in order, and then y'all can entertain a
Okay, sure.
motion on that. I'm drafting the final language for the clerk thing.
Okay.
Okay. So, the first change that everybody seems to agree on is on page 3, it's Article 4, Section 1B1. It will now read the chair, comma, vice chair, comma, and secretary. Shall be selected. And then, the next proposed change that based on your recommendation, I've drafted language for it, is in below in subsection C3. It's going to say secretary, it shall be the duty of the secretary to serve as the chair pro tempore of the board in the absence of the chair and the vice chair, period. The secretary shall also, this is my suggestion, and you can tell me if you agree with this. The secretary shall also prepare the agenda and minutes of the board's meetings with the assistance of the clerk. So I'm just going to put the clerk there. And then we'll have a sub A that says clerk, parentheses, election staff. And that's going to say the elections director shall designate a member of the elections department staff to serve as clerk, who will assist the secretary in preparing the agenda for each meeting and maintaining the minutes of the board's
We need
meetings.
to insert meeting. I
Right.
did mark that on my,
Yeah.
sorry, I did miss that.
No worries.
On,
Yeah.
4,
Yep,
section 4.
yep.
It
That's,
just says
yeah,
for each.
I just read it there.
Your mic,
read
Debbie.
them.
Sorry to interrupt you. Your mic.
Oh.
Yeah,
You can't hear my big robust voice.
yes.
I did mark that one, where it just says for
Each,
each,
yes.
and need to insert each meeting.
Yes. Well, with the other, I had also inserted that there, but I think what I probably originally had planned to do was just say to prepare the agenda and maintain the minutes of the board's meetings. But was
I'm
just-
good with
was-
that, I'm good with that. It just, each
yeah,
doesn't
right.
make sense
Right.
as is.
And then I was gonna add, propose, and you could tell me if y'all want this or not, as a sub B, there would be, the heading would be executive session minutes. And I'll say, it shall be the duty of the secretary to take minutes during executive session. The board, comma, in its discretion, comma, may invite the clerk into executive session to assist with taking minutes.
Okay.
So those are the proposed revisions for this clerk and secretary. And then the last two revisions would be on page 6 under Article 7, this would be 7, Section 1A4, Roman numeral 4, where at the end it would, instead of an interim director, it would say acting elections director. And then in subparagraph 5, it would say the board shall appoint an interim elections director to serve
Okay.
until the successor is appointed.
Thank you, Mr. White. Are there any questions about the proposed revisions to the extent that there would be a need to ask Mr. White to revise the language that he has proposed? Okay. Hearing nothing in response to that, I will entertain a motion to approve the amended and restated bylaws of the Cobb County Board of Elections and Registration as amended in the manner in which Mr. White just shared with us.
So moved.
Okay, is there a second?
Second.
Is there any discussion? Hearing no discussion, all those in favor? The motion passes unanimously. Thank you. It's a long time coming. I think those bylaws have been the way they have been since, what, 83? 85?
86, something like that, yep.
Very long time. All right, exactly. Job is done here. All right,
Older than our director.
but not older than the chair. All right, moving on to the next item on our agenda. Any new business? No new business. All right, speaking of the director's update.
Thank you. Just have a few slides to go over for everyone today. So first, I'm going to talk a little bit about the legislative session outcomes and what we can expect for next year. I'll talk about the upcoming elections we have and then give an update on what each department has been working on in preparation of our elections. So for our outcomes, we had 3 election-related bills pass this session that are waiting to be signed by the governor. So the first was SB 199, which deals with campaign finance. We were really excited about this. This was a Gavrio priority. One of the provisions in this piece of legislation would remove our office as being the middleman for the local campaign filings. So anyone who's run for office knows that we have to facilitate the reception of all of the campaign filings, and then all we do is just turn them over to the state ethics board and kind of a middleman there. So this would remove our office from that. So all local candidates would just be filing those campaign reports directly with the state ethics board. So we're very excited about that. It will go into place January 1st of 27. So there'll be some time for implementation there. Next is HB 296, which was a piece of legislation regarding the use of virtual driver's licenses, where it's acceptable, where it's not. And there is a provision requiring a physical driver's license to vote in person. This has always been the case for us. We've never accepted, Apple Wallet version of driver's licenses or anything like that. But since they expanded in law where those types of driver's licenses are accepted, they made sure that it was codified that cannot be used to vote in person. So no issue for us, no impact there. And then HB 426 changed the election of the chief magistrate judge to be from partisan to nonpartisan. So we'll see that fall under the nonpartisan general election in those years, those even years that they're on the ballot. Next is a group of pieces of legislation that was passed by only one chamber. So they're not up to be signed by the governor and go into law, but they will be at the top of the agenda at the start of the next session next year. So I wanted to make sure to highlight them so we can be prepared for the next session. So there were two different election omnibus bills. A lot of them had really similar provisions in them, but there were some differences. The House version was HB 397 and the Senate version was SB 175. There was a provision in there that Gavrio had asked to be a priority, which was to limit the SEB's ability to make rules within 60 days of an election. And then if they did enact a rule within 60 days of an election outside of emergency reasons, of course, that it would go into effect 30 days after the election date. So that was in both of those omnibus bills, so we were excited to see that language in there. Still will be one of Gavrio's priorities next year as well. HB 414 and SB 177 were different flavors of campaign finance bills. 414 was just defining some terms, and then 177 specifically talked about foreign funding in election campaign finance. And then SB 214 is a bill that we worked closely on with Senator Burns on hand-marked optical scan ballots. A lot of discussion around his bill, SB 214, as well as Senator Moore's bill, which was hand-marked, hand-counted paper ballots. Seems like this is a priority of the legislators, is to move towards hand-marked ballots. And so we've built a great relationship with Senator Burns in working on this bill, and we look forward to working with him in the off session to make sure that when this bill is, if it is passed and enacted, that it's effective and that it can be done in an effective way for all counties, to make sure that voters are informed, poll workers are prepared, and it's not rolled out at the last minute right before a large election, like an even year election.
I have one point of clarification, but does anyone have any questions for Ms. Fall about the legislation that she's reviewed?
I do have a question. I believe last session under, I want to say it was under 189, we were required to remove the QR code from the ballot. There's been a lot of chatter, whether it's true, false, or somewhere in between, that we will have no legal way to vote currently with that QR code if we do not upgrade the equipment.
So it's not how the result has been explained to us, so I'll give you what we've been told. So there was a piece of legislation in SB 189 that required the removal of the QR code from the ballot. So what that means is that we could continue using our current equipment, but when you vote on a BMD, instead of it printing off just your selections with the QR code, it would print off what we call a full face ballot, which is the same ballot that you get when you vote absentee by mail and you fill it in. So it would be a full face ballot with your selections bubble pre-filled in. And so the issue with that is that, like last May, we had a 2-card or 2-page 19-inch ballot. The printers that we currently have only print up to legal size paper. We routinely have longer than legal size ballots. So not only would the software have to be upgraded to allow the switch of the Dominion equipment to print those full face ballots instead of the QR code ballots, we would also have to replace the printers and the way that they're configured inside of our carriers. So I know that there was an original provision in the budget to have that upgrade to allow us to do that. And it's my understanding that that was downgraded to a smaller $14 million upgrade instead. So what was told to us was that if the funding wasn't there, then we would not be able to comply with the law and we would continue using the equipment as it stands today.
My understanding is it does not, to do what you described, it does not require an upgrade on the software, the grand poobah of the software upgrade. It's a matter of being able to flip a switch on the internal workings during LNA. That there is actually a selection, maybe Michael can answer that, that shuts off that barcode, QR code.
That is not our understanding of how the equipment works. So in order to switch to a full face ballot, the Secretary of State team would have to come in and touch every single piece of ballot marking device and upgrade the system itself, every single one, in order to allow it to print the full face ballot. It's nothing within our control.
I think that's something we probably need to verify. There's way too much smoke for there not to be a small fire here.
Sure, I can follow up with
Okay.
CES on that.
Thank you.
The point that I wanted to just confirm, when you were talking about the collaborative effort with Senator Barnes about SB 214, when you said we, you're referring to Gavrio, correct? Or
Yes, the
Cobb?
Gavrio Legislative Committee.
Okay,
Yes.
just wanted to be certain, just for those, I know that was it, I just wanted to be certain that we're all on the same page. However, you did raise a point in responding to Ms. Fisher's question that I want to dig a little bit deeper into very briefly. The guidance that was provided with regard to the downgraded budget and the fact that we may not need to comply with a provision of the current Georgia code, am I parroting that back to you correctly?
Yes, nothing has been received in writing officially from the Secretary of State's office. That's just what we've been told through the grapevine, if you will.
Okay, and that's, you know me well.
Yes.
That is exactly where I was going. To the
Yes.
extent that someone, presumably the Secretary of State, should be providing that to us in writing, to the extent that a county is being advised that they need not comply with Georgia code as
Right.
it's presently in the law,
Right.
is concerning for me.
They typically provide a training and an update after the legislative session is over to
Right.
let us know what they're doing and what we need to do.
Okay.
So unfortunately, the Secretary of State is hosting in-person training during the week of our April 29th election. So I am sending we had 4 spots. I'm sending a few managers the day after the election, which was the day that was most relevant to us. And I'm hoping that they'll be covering that then, because typically those are types of things they like to cover in person instead of in webinars.
Right.
And so we are hoping to receive that information in writing then. And if not, we will be sure to follow up very quickly after that training is complete.
Okay, and if you receive that in writing, whether it's in printed materials, I presume maybe the course materials share, but I also would tend to think the Secretary of State would send something from his office, not just, something as.
Like an OEB or something.
Yeah, exactly, something as consequential as do not comply with the law that's on the books, to me, should be communicated formally, across the state, and not just something that's covered in a training session. But again, if you receive it, if you'll share it with the entire board.
Of course, absolutely.
Madam Chair, the issue you raise is exactly where the smoke is coming from.
I would imagine so.
On what I addressed with Director Fall, because there's a lot of people who actually have a law degree, whereas I don't, that do not believe the Secretary of State has the legal authority to direct that a law not be filed. I personally believe that is a correct assumption, and that if that order comes from anywhere, it should be the AG, not the Secretary of State.
I tend to think that there would be litigation on that, but that's not within my purview, so we'll see. I just want this office covered.
I do too.
Okay.
It will be an interesting thing to follow.
Okay. The last thing to note that I don't have listed on this slide, but there was a House resolution that was passed, House Resolution 885, and this created a House study committee on election procedures. So according to the House study procedures requirements, it'll be a 3-day study committee unless more days are authorized. And Gavrio is hoping that our members will be sought out for testimony throughout that process, and we're looking forward to more information as it comes out on HR 885. Okay. So next up is upcoming elections. So we do have the April 29th special general election for Commission Districts 2 and 4 at the end of this month. ABM application deadline is this Friday, April 18th, and AIP will start this Saturday, April 19th. Will be closed Sunday in observance of Easter Sunday, and then we'll continue Monday the 21st through Friday the 25th for early voting. We'll have Election Day Tuesday, April 29th, from polling places will be open in Districts 2 and 4 from 7 a.m. to 7 p.m. And of course, ABM ballots must be returned to our office by 7 p.m. on Election Day. So that is our very quickly approaching election. In addition to that, we also have a few more elections also quickly approaching. We had at the state level the Public Service Commission qualifying event. So there are 2 public service commissions that will be on the upcoming ballot, Districts 2 and 3. It is a statewide election. All registered voters are eligible to vote in both District 2 and District 3. The districts are only relevant to where the candidates live, not to where the voters vote. So we had 1 Democrat qualify in District 2 and 2 Republicans in District 2. One of those Republicans is the incumbent. In District 3, there were 4 Democrats that qualified and then 1 Republican, and that 1 Republican is also the incumbent there. So when you go to vote in the public service election, which I'll show a slide in a minute with the dates, you'll have both Districts 2 and 3. It's a normal partisan primary, so you'll declare if you would like a Republican or a Democrat ballot for that. We also are finishing up our last municipal contract for our November municipal elections. 6 of the 7 cities will be hosting municipal elections this November. That's all cities except for Smyrna. And all 6 contracts will be ready for signature at the May 5th meeting, so we can officially declare those and sign those and get those copies back to the clerks. So due to those qualifying numbers, we do believe it is highly likely that we will have a statewide Public Service Commission runoff on July 15th in the Democratic portion for District 3. So we are preparing for that, especially because that is the date of the Major League Baseball All-Star Game here in Cobb County. So we will be inundated with out-of-towners and visitors enjoying the festivities. So the team is working on a plan to temporarily co-locate all the precincts within a 3-mile radius of the stadium to other locations to help alleviate traffic. Of course, our biggest concerns are parking and availability to get to the sites for voters, as well as the ability for those ballots to get back to our office on election night, since polls will be wrapping up about the same time that the game is ending. We don't want ballots and memory cards stuck in gridlock on the interstate trying to get back to our office. So we'll have a plan at the May 5th meeting for the board to vote on in the event that we do have a July 15th runoff, where those 9 precincts would be co-located to other existing locations outside of that 3-mile radius.
I have questions, but I will reserve them so you can finish your
Sure.
report.
So April 29th, like I said, is our next election, and then that PSC Public Service Commission statewide primary will be June 17th. Statewide, you'll vote at your normal polling place. If there is a Democrat runoff for the District 3 race, that will also be statewide. So anyone who voted a Democratic ballot in the June 17th primary or didn't vote at all in the primary will be eligible to vote in that Democratic runoff. Then we'll have those 6 municipalities in conjunction with the PSC statewide general on November 4th. And then if any municipalities require a runoff, that would be December 2nd. And the only city that does not have runoffs is Kennesaw. So all 5 other cities could possibly have a runoff depending on the size of the race. And those are our upcoming elections this year that we know of.
Here we go. Okay. I was going to start with the publicizing AIP, which begins this Saturday.
Mm-hmm.
I don't know that I've seen anything on our Facebook page or our IG page. So the plan, recognizing that there might be a bit of fatigue around voting in the county, what are we doing to publicize?
Sure, so those posts will
AIP.
start this week ahead of Saturday. And then the commissioners also have all those dates, and they'll be included in their newsletters as well as their updates. So they have that. And then we work with the county comms to push out those notices of first day, last day, kind of the time-sensitive ones on the county-wide social media as well.
Okay, and the only reason I raised that is obviously this, for those that observe it, this is the Easter weekend.
Right.
And so getting that information out sooner rather than later, close to the 19th might be helpful.
Absolutely.
Back to this co-location of 9 precincts. Do we have do you have a list of those precincts?
I do. So they're not all going to be co-located together. So it would be a maximum of 4 polling places together. 1 polling place would be 4 together, and then 3 polling places would be 3 polling places together. They're all large sites. So the ones that need to be co-located are Vinings 01, Vinings 02, and Vinings 04. And then Dobbins 01 and Dobbins 02. and then CA 01, which is Chalker 01, and then Chattahoochee 01, and then Smyrna 2A, Smyrna 1A, and Smyrna 6A. Those are the 9 that are inside of the 3-mile radius.
Right, I voted one of those. Can you provide that list to us and then kind of the proposed plan?
We're still finalizing that, so as soon as I do have it, we're working on the site surveys right now to make sure the sites that we're hoping to accommodate can due to the equipment and parking. So as soon as I have that finalized by the end of this week before the holiday, I'll get that to you guys.
Okay, and that was my point, just to get it to us prior to.
Absolutely.
Because it's a significant change.
Yes,
For
yes.
our voters. I definitely understand being proactive. I do wonder whether, just me personally, whether that's necessary in as much that our voters will have been voting at these locations February, March, April, June, and then all of a sudden that's a pretty drastic change. July 15th, they would have just voted 1 month prior somewhere else. And I'm not minimizing the concern around the ability to get from point A to point B as far as them getting to the precincts to vote and obviously to get the materials, ballots and memory cards back to us. But that does appear to be a pretty significant change to undertake, 5 elections into the 2025 election cycle.
Sure. So we are legally required to send them postcards, of course, to let them know of the notice. So they will be able to receive those. So we'll get those out. The idea is that we would have this plan approved at the May 5th meeting. That way, on election night, once we know if there is going to be a runoff or not, then we could submit the order for the postcards the next day. That way, they can be printed and dropped right away with minimum turnover. So that's the thought in working ahead. And we have been in conversation with our public safety partners on this because that is going to be such a large draw for public safety to be at the Battery, which will really minimize their ability to assist us in their normal capacity, especially the sheriff's office, since we typically work with their special operations division. So we are working through the conversation to make sure that we're going about this the right way.
Okay. We definitely appreciate the heads up and having the information prior to the date on PUN,
Yeah,
which
absolutely.
the board would be anticipated to vote.
Like I said, tweaking those site surveys to make sure circuits are good and parking lots are plenty big enough.
Okay, sounds good. Ms. Fisher and then Ms. Saffron.
If we're changing the location of a precinct, aren't we required to follow the notification, the 2-time notification?
We would.
Okay, and when would that be?
So we would have that after it's voted on, or just prior to May 5th. We've already have set up the MDJ to go out, so it'll be the Friday before the May 5th meeting, and then the Friday before that as well. It's always the 2 Fridays before the meeting. And it would be a temporary relocation, and that would be noted in the advertisement of the legal organ.
Okay, so if it wasn't passed, then what's Plan B?
We would listen to the board's ideas of what they would like to see instead if they didn't approve of the co-location plan, and we would get together with the elections team and the prep team and site survey and our partners in public safety and see what we could do instead.
Okay. Maybe since we aren't that far out from May 5th, the sooner you can get us those lists, the better.
Before the
And if
holiday at the end of the
They have
week.
to be amended, they have to be amended.
Yes.
Appreciate it.
Ms. Saffron.
Makes sense why we would need to co-locate. I would just be concerned with making sure the voters get the message. And would it be possible at the June 17th precincts to give them handouts or something that said, in the event of a runoff, you will vote at fill in the blank precinct? So, because I would hate for them to drive through the all-star traffic to the wrong precinct only to be told to go somewhere else. And I'm assuming if they're voting in the runoff, they most likely voted on June 17th. So can we let them know on during that June 17th day?
Yes, I don't believe there's a prohibition on handing out any literature of that nature. I just want to double check the code just to make sure. I don't believe there is, since it's not partisan. So we will do that, and then we can definitely do that. And in addition to the postcard requirement, there are very, very stringent requirements of what kind of signage is at those precincts that aren't being used as well. So there's a large sign that's up for the whole week before the election, as well as 3 smaller signs that are put out the day before the election as well. So we'd be complying with all of those as well. But let me double check the code section, and I can include that in the plan I guess it'll be Thursday since we have Good Friday off.
And then I guess to the extent that we will be, it sounds like we'll be relying on postcards. I know we've had challenges with vendors with respect to postcards. Are you and your team confident that the vendor that we will have in place for the distribution of these postcards, because it's always critical. This co-location makes it even more critical.
Right, yes.
That our postcards are mailed out in a timely fashion, they're accurate, and they land in the mailboxes well enough in advance of the July 15th.
I can't speak on behalf of USPS's turnaround time, but I am confident in our vendor's ability. That's why we want to do it early. That way they could drop them on June 18th and get that list. So they would have the list ready to go. We would give them green light. We're having a runoff, and they would be able to print them and drop them on June 18th.
On June 18th, okay, because that was going to be my next date.
Yeah. Yes.
Again, reading my mind, I appreciate it. Any further comments or questions about this particular, or for that matter, Director Fall, did you have anything further for your report?
That was it for this one,
Okay.
for this slide, yes.
For this slide?
Yes.
Okay.
Great. Just a few more quick things. These are the recent hires, open recruitments, closed recruitments, and upcoming recruitments that we have. We've recently hired one full-time assistant supervisor in the AIP division, a part-time election technician in registration. Those are our receptionists, the election technicians in registration. And then a part-time voter registration specialist also in registration. We have 3 closed recruitments waiting on the interviews for those, all 3 positions in registration, which is our largest division, so that's why there's so many positions there. And then we do have a current open recruitment. It is for our summer intern, which will be focused on communications and outreach in the admin division. That closes 4/17, so this Thursday before the Good Friday holiday. And then our upcoming recruitments with TBD dates are a part-time project coordinator. That's what we had discussed as the data analyst. The working title right now with HR is project coordinator, so that's what that one is. Still deciding if that's gonna be in the admin division or the registration division. And then full-time supervisor in the prep center, and then a part-time elections coordinator, one also in the prep center. So we'll have hopefully updates. We just finalized the full-time supervisor language this morning and still working on the project coordinator language as well, so should have those soon.
The prep, I know what the project coordinator is, that's a net new. The prep center positions, is that a result of attrition or?
So the supervisor position is actually due to moving site survey from the elections division over to the prep division. Prep was the only division that didn't have a supervisor. Okay. So we moved the 2 site survey positions and what was the site survey supervisor position to prep. Mm-hmm. So this will just be a general prep center supervisor position. It won't just be focused on the site surveys team. And so it'll be on all 3 parts of the prep center. And then the part-time elections coordinator, one position is one that was open, someone moving to a seasonal capacity to spend more time with their family.
All right, and the same questions with respect to the current recruitment that has closed and pending interviews. My understanding is, at least on the registration specialist, I believe they have accepted positions elsewhere in the office.
Yes, one was due to the result of losing one of our staff members recently, and then the others were due to people's internal promotions.
Okay, excellent. Great that we're promoting from within.
Yes.
Does anyone have anything further on this slide? Okay.
So last is just the other departments that we have. So absentee, I just have some current absentee numbers for you as of this morning. I previously mentioned upcoming dates and deadlines for ABM and AIP under the April 29th slide. So as of this morning, we had received a nice round 200 applications for this election. 150 of those had been accepted and 50 were in further review. 48 of those were rejected. 2 of those were cleared for provisional issuance. So we've issued a total of 152 again as of this morning. 150 of those were regular and 2 were provisional. After the morning mail run, we had received a total of 4, and all 4 of those have been accepted. We're not doing any early processing of ballots, so all processing of ABM ballots will be done on election day. Last, elections has its last day of training this Thursday. Sorry.
Mr. Bruni, you're.
I have one question about.
I apologize for interrupting you. Your mic, please.
Sorry, one question about the absentee ballots. I know that special elections, like the commission district elections, we don't do the carryover process like we do in normal elections.
Correct.
Will that be the same for the PSC and the municipal elections?
That is correct. So the code does not allow us to use the rollover list for special elections. So because the Public Service Commission election is a special election, there will need to be independent applications submitted for that, as well as for the November election, as it is both a regular municipal general election, so it's technically the first and only regular election we have this year, so it's independent of the other applications. But then also the PSC is a special, so people need to apply to that. So all of those that have been eligible for rollover, that they check that they're either elderly or disabled, we've been mailing them letters letting them know that there is no rollover for these elections, so they need to submit independent applications. So we've been being sure to follow up with them to let them know they're used to checking that box and getting the ballots in the mail, and that's not how the elections this year were, just because they're all specials.
Good, thank you.
Sure.
Good point. I appreciate you raising that, Mr. Bernie.
The very nuanced rule when it comes to the applications that's particularly effective this year. So like I was mentioning, elections, the last day of training is this Thursday. It's been great to have everyone back in the building. We're fully staffed for election day, just filling in those last few standby positions for the last few coming in to get trained. Prep completed LNA very quickly. It was a nice, easy LNA for us. And then they'll start deliveries next week. Registration successfully keyed approximately 17,000 registrations by the deadline prior to this election. They had a lot from the beginning of the year after the November election, as we were put on hold for that really quickly approaching February 11th election. So they were able to key those in the tight 3 weeks that they had. So we're really proud of them. I also want to take a moment to touch on some of the things that were brought up in public comment in regards to the voter list and talking about voter registration. So the summer purge that the Secretary of State has been discussing, which I know is mentioned, that's a normal event to happen in odd years. So the way that our voter list maintenance system works is that there's 2 federal election cycles if there's no activity. So 2 federal election cycles would be 4 years. Then you're put on inactive status. And if you still have no activity within 2 more federal election cycles or another 4 years, then you're rolled off. So of those 400-some thousand that's being removed from the state, we're at just under 16,000 here in Cobb County that will be removed as part of that purge in early summer for those that are on that 4 years of inactive and now they're rolling off because they had no activity. So that'll be that purge. We haven't gotten a date on that yet. We've just been told early summer. So we are always in compliance with any voter list maintenance activity. And then additionally, there was a question about citizenship and registering to vote with citizenship. So I wanted to address that. So although it may only take a few minutes to register to vote, when you register to vote, you're not automatically on the voter roll, right? It goes through several checks and balances. So you submit your voter registration, whether in person, whether in the portal, whether you fax it in. We check our very active fax, if you can believe that or not. And someone will key that. So when I say we keyed 17,000 registrations, that means we physically keyed 17,000, either new registration, updates, removals, whatever those were during that time. So when you submit your voter registration, we key that in and then it goes into a holding pattern and it's checked several different ways. So first it's checked by DDS. That's where we check your citizenship. So if you provided proof of citizenship to DDS, then they give us the green check on citizenship. If you did not provide citizenship documentation to DDS, or you don't have a DDS record, you don't have any type of driver's license or non-driver ID, then you get put on what's called citizenship pending status. So if you were to go vote, you may be on the voter roll, but you would not be allowed to vote a regular ballot until you can prove your citizenship status. So you can either provide a copy of your citizenship documentation to the poll worker, they can allow you to vote, or you can cast a provisional ballot and then provide that citizenship documentation directly to our office. And as long as that's by the provisional deadline, then that provisional ballot will be counted. So we check citizenship through DDS. We check the felon records to make sure that you're not a decommissioned felon, right? Or if you have completed your probation and everything required with your sentence, and now you're re-registering to vote, that gives us the green light to place you back on the voter roll if you finish that. We also check with DDS on age. You can be 17 and a half to register to vote. So we make sure you actually are that age, that your birth date is correct. And then we're also checking with the probate judge for any individuals that have been ruled mentally incompetent. So anyone who has been taken under guardianship and ruled mentally incompetent doesn't have the right to vote. So we check for those things. Once all of those things are complete, then you're placed on the voter roll. So either voter roll, citizenship green check, or citizenship pending, then you would have the opportunity to cast a ballot. So that's a little bit about the system that we have in place to make sure that people, when they register to vote, are those required things, that they sign an attestation saying that they are a citizen, they are of the age of 18, they're not a felon, and that they haven't been ruled mentally incompetent. So all 4 of those things are verified. So just to touch on that. Last but not least, we're really excited to have Good Friday off and spend Easter weekend with our family. So all Cobb County offices will be closed this Friday, including our office, but we will be back open on Saturday for early voting at all 4 locations, including our office. And with that, that is all I have. Thank you. Yeah, sure, Mr. Bruni.
We only open at 2 locations?
2 locations, no, 4.
Saturday.
We're at 4. 2.
On Saturday.
Yes,
Smyrna
because
is
it,
closed.
yes, that's right. Thank you. Yes, City of Smyrna
Your mic.
facilities are closed.
Your mic.
So City of Smyrna facilities are closed for all of Easter weekend. And so we're just going to be open at our office, and then is it South Cobb? South Cobb Community Center will be our 2 locations Saturday, and then all 4 locations Monday through Friday, 7 a.m. to 7 p.m. Thank you.
Yep.
Forgot about that.
Does anyone have any additional comments or questions for Ms. Fall with respect to her report?
I do just have one comment on the Secretary of State's voter roll cleanup. They actually do the removal, is that correct? Not us?
That is correct.
Okay, and also, I think I heard you say we are only removing 16,000?
Cobb County, for that particular purge, in accordance of those who have been inactive now for 4 years or 2 cycles, Cobb County's portion is just under 16,000.
Well, so for the people in the audience who raised the issue on voter rolls, both for, cleanup for, and opposed. Back in February, the Secretary of State's voter roll database for Cobb County had over 90,000 people on the inactive list and almost 40,000 that were 10 years or longer. Just FYI, we do need to do maintenance beyond what they're doing. I'm just going to keep reissuing that complaint until we actually pay attention to it.
And I'm just going to say that that complaint is not a validated number because those numbers are not necessarily people who have been inactive for the amount of time as required by the NVRA.
I beg to differ with you, Jennifer. The voter rolls clearly state inactive that come from the Secretary of State. It is a paid list, not one you download. And the Secretary of State would be the person declaring them inactive.
Any rebuttal? I'm sorry, the lawyer in me, it was a horrible joke, I apologize. Any rebuttal, but honestly, there obviously is a lot of attention on this particular topic. The 16, and just to be certain, the 16,000 as they were identified as a subset of the 400,000 that's been referenced in the news, that's a number that was provided to you by the Secretary of State. They went through the process of identifying those, am I correct?
Correct.
Okay, excellent. Yes, sir.
I just want to point out, and I've mentioned this several times when there have been questions about the number and the length, why do we have people that haven't voted since 2013 and 2012 and those kind of things. And this is what was coming that I've referenced several times, where in 2017, Brian Kemp was sued for the use it or lose it policy. Mm-hmm. And they paused the purges then because they were in danger of losing a lawsuit at that point. So there was a year or 2 pause. And then in 2019, they kind of settled that case, and Kemp signed, and he was then governor, signed a bill that stretched it from 7 to 9 years. Mm-hmm. So between that pause and the new thing that required basically a 4-year and then a 5-year period, we're now catching, this is what that is. This is what the 400,000 is coming from, is those voters that was sort of caught up in that. The normal cycle got shifted from 7 to 9, and in the middle there was a pause. So now we're getting this big wave of people who are coming off. And this is what I've referenced really multiple times over the last couple of years, that yes, there's a lot of people that look like that really haven't voted since 2013, 2014, and that's because of what happened in these lawsuits, and this is coming, and now it's here. And so this is the Secretary of State going through, and those that got paused and got caught up in that pause, along with all the other people that are now on the natural NVRA cycle, they're rolling off based on the legislation that Kemp signed in 2019 and on that pause. So this is where that's coming from, and that, like it's been pointed out, this is the Secretary of State making these removals under 234 and 235 and those sections that deal with inactive voters and those to comply with the NVRA.
All right, well, thank you. I think that underscores the point that context is key. Having context that there was a pause hopefully provides some clarity for those that were not aware of that. Any board member comments, as that's the next item on the agenda? I just have one. So our state election board on Friday issued a notice about an upcoming rulemaking hearing, and just wanted to raise it to your attention, Director Fall, and perhaps for your counterparts on the Gavrio Legislative Committee. The proposed revision to this particular state election board rule would require the election superintendent or their designee to produce ballot images and cast vote records in a particular format to requesters within 72 hours of a request received after the closing of polls. So just again, wanted to flag it for you and Gavrio. I believe that meeting will be held on May 13th.
Yes, I believe we're meeting next week after Easter holiday to discuss that as a committee.
Okay,
Thank you.
perfect. Does anyone else have any further or any comments, board member comments? Nope, okay. Mr. White provided us with a comprehensive update of, and thank you for that, it was very comprehensive, a comprehensive update of the pending legislation, and I believe we as a board, litigation. Of pending litigation, and I believe we as a board determined that the executive session is not needed. Okay, so no executive session. And our next meetings coming up, April the 29th, that is our election night meeting. That will be held at our office at 995 Roswell Street. Later that week, we will have our pre-certification meeting that Friday at 3 p.m. also to be held at our office on Roswell Street. And then finally, May 5th, that will be our regular meeting at which we will certify April 29th election results that will be held here at 3 p.m. If there is nothing further, then we will adjourn the meeting at 4:37 p.m.